Good afternoon, everybody. Welcome to our round table. Ladies and gentlemen, esteemed guests and distinguished participants, good afternoon again and welcome to the Arab Ancestral Days. Let's call it the Qatar Ancestral Day in cooperation with the Ancestral. This is our round table with our esteemed College of Law of Qatar University, and the topic is trends in resolution of technology-related trade disputes. We are thrilled to have you with us today on this Wednesday, November 1st, 2023, for what promises to be an enlightening and insightful discussion on the critical issues at the intersection of technology and dispute resolution. I am Nader Ibrahim, a professor of commercial law in our college, your host and the moderator for this event. And we are, as you see, gathering virtually, semi-virtually, but we are managing to do it, and we are thankful to the team who helped us to achieve this. We are grateful for your presence despite this digital divide that separates us. Today, we come together to address one of the most pressing concerns in today's international trade landscape, the resolution of technology disputes, and at the same time, the different types of alternative dispute resolutions related to it. In the spirit of international collaboration and harmonization of trade laws, we are deeply honored to have the UNOCITRAL's active participation in this event. UNOCITRAL's dedication to the development and modernization of international trade law has been instrumental in promoting legal frameworks that transcend national boundaries. We care about that. We support this objective in Qatar, and in our college, we support international trade law uniformity. And in light of this objective, we meet today. We have two distinguished speakers who will share their expertise on this matter. Our first speaker, representing UNOCITRAL, Mr. Takashi Takeshima. He is a legal advisor at UNOCITRAL. He will delve into the role of UNOCITRAL in solving technology disputes and related issues to today's topic. Our second speaker, dear colleague, Dr. Mazen Dahal, who is known for his expertise in technology-related topics like the fintech and things like that, and he will address some aspects of the complexities in online such transactions. Following these two presentations, we will engage in a moderated discussion on different related issues, and there will be a conclusion by my colleague, Ms. Reem Al-Khal. Then, this is our agenda. Thank you for your participation again. And let's start with our first speaker from the side of UNOCITRAL. Now, it is up to you, Mr. Takeshima. Yes, we are waiting for your presentation, Mr. Takeshima. Do you hear us? He is mute. Mr. Faisal is. Yes. Please send him a message.
Yes, thank you very much for the kind introduction. And I would like to begin by expressing my sincere gratitude to the organizers for having me. It is a great pleasure and honor. And I would also like to express the UNCITRAL Secretariat's appreciation to the collaboration with Qatar University for this Arab Day. Um, Allow me to take a moment to screen share. Oh, may I screen share? I think there's another slide on the screen, but on the list. So I hope the slides are visible. Okay, great. Thank you for confirming. Yes, so I'm very delighted to talk about UNCITRAL's work on technology-related dispute resolution, and also towards the very end of my presentation about dispute resolution in the digital economy. But before I go into the substance, I just wanted to provide a quick overview about what UNCITRAL is. UNCITRAL is an intergovernmental body with limited membership. Currently, the membership is 60 member states, 65 member states, which will be expanded to 70 in 2025. UNCITRAL is the core legal body within the UN system, established under the UN General Assembly. Um, and its establishment dates back to 1966. So we are quite a long-standing body, and UNCITRAL's mandate is the progressive harmonization and modernization of international trade law. Um, in terms of how we work, is that we work in three different levels. We have the commission, which is the body, the decision-making, policy decision-making body, which meets annually during the month of June or July, once a year. And we also have working groups. The working groups are the ones that are tasked to develop the details of the legislative or non-legislative text. And finally, the Secretariat is the institution where I work with. We are here to assist the Commission and working groups and to facilitate their deliberation by providing inputs through documents and other means. So international trade law is a very broad area. So the working groups, we have 6 working groups to cover the important topics. Um, the working group that I will be speaking about today is working group 2 on dispute settlement. But aside from this working group 2, we have working group 1 that works on MSMEs, working group 3 on ISDS reform, working group 4 on e-commerce, working group 5 on insolvency, and finally working group 6 on negotiable multimodal transport documents. As you can see, working group 2 and 3, they are both, the 2 working groups are dedicated to dispute resolution, and it shows how dispute resolution is one important pillar within UNCITRAL's work. So let me now talk about the current work of Working Group 2 on tech-related disputes and adjudication, which is probably the focus of this roundtable today. The Commission has tasked the Working Group to develop texts such as model clauses and other legislative or non-legislative texts on matters such as shorter timeframes, appointment of experts or neutrals, confidentiality, and the legal nature of the outcome of those proceedings. This is in part to respond to the needs of the tech industry that requires a speedier resolution of disputes that involves expert knowledge in specialized fields and in which confidentiality is key. So the three elements, speed, expertise, and confidentiality are the three key aspects of this project. And in the following slide that you have here, in this slide, you see a list of texts which are being considered by Working Group 2. So I'll just walk you through in the order. Model Clause A is about highly expedited arbitration. I'll go into the details later. Model clause B, neutral third-party determination. Model clause C, experts accompanying the tribunal. Model clause D, plus guidance on confidentiality. And finally, guidance and evidence, which is with a special focus on digital evidence. So there are quite a few texts that are being contemplated by Working Group 2 at the moment. So for the purposes of today's roundtable, I believe model clause A, which is on highly expedited arbitration, C on experts accompanying the tribunal, and D on confidentiality are most relevant. So I will focus on these model clauses. The model clauses are basically being developed so that parties can pick and choose so that and include them in their contract, specifically in their dispute resolution clauses. So it's not like all the model clauses from A to D are like a complete package that you have to take all as a whole. So the first model clause we have on the screen here is model clause A. This is again on highly expedited arbitration. As you may know, the UNCITRAL arbitration rules has in an appendix the UNCITRAL expedited arbitration rules, which shortens time frames and provides means to expedite the proceedings compared to regular arbitration under the UNCITRAL arbitration rules. So, but we have heard calls from the tech industry, especially the startups who are in desperate need of cash, that the 6-month time frame provided for in the expedited rules were still too long, and in response, further shortened time frames are being contemplated. For example, the time frame for making the award being considered in this model is a very short one, such as 60 days or 90 days, and the time frame accordingly, the time frame on the appointment of the sole arbitrator is shortened to 7 days, which is 15 days under the expedited rules. And as it is currently being contemplated, the time period in which the consultations between the parties in the arbiter tribunal should take place, which is 15 days in the expedited rules, is also shortened to 7 days. But as you will probably notice, it should be kept in mind that when time frames are shortened, it could create tensions with due process rights or a party's opportunity to present their case. The parties agreeing to this model clause should recognize the risks associated with it and the need to act particularly expeditiously. But even still, it is always not easy to envisage what kind of disputes may arise upon contract formation. The disputes are something that occur in the future. So there may be circumstances that conducting proceedings within the highly expedited time frame are no longer justifiable. And in anticipation of such circumstances arising, safeguards to extend the time frame on the tribunal's own initiative and to have recourse to the UNCITRAL regular rules or the expedited rules without the modification of these shortened time frames under these model clauses at the request of one party are also being provided. So this is a very quick overview of Model Clause A. I do have slides for Model Clause B, but this is more about the adjudication side of the project, which is about construction cases rather than tech disputes. So maybe I should skip this slide and draw your attention directly to Model Clause C. So Model Clause C is on experts accompanying the tribunal. Considering the discussion we had quite lately in September, the working group session, I think the name will likely be changed to technical advisors or other similar names, but the idea to form a model clause remain unchanged. And if you're familiar with the UNCITRAL arbitration rules, you would recognize that already in Article 29, it has a provision on tribunal appointed experts. But if you take a closer look, it will tell you that the provision on tribunal-appointed experts has its own limitations. The experts are requested to report in writing on specific issues. So the arbitral tribunal, in consultation with the party, is expected to identify the specific issues to ask the experts to report in writing. So the question here is, are arbitral tribunals capable of identifying the issues without assistance in understanding the technical aspects of the case? Especially this is so when this question becomes relevant, considering that not all parties are helpful in that regard, as they are really committed to their own case theory. So this is the area where this expert appointed pursuant to this modus clause would become useful. So as you see in the slide, the role of the expert being contemplated in accordance with this model clause is to provide explanations. It's not here in the slides, but the idea is to have not only written explanations, but also oral explanations as the need arises on the technical matters. So the idea is that the expert will sit together with the arbitral tribunal and accompany it throughout the proceedings. In appointment, the arbitral tribunal should consult the parties on the area of technical expertise required. Without that, there's no way that the expert could actually be useful. And also the other important part of the model clause is to provide that the terms of reference would need to be established so that the working method of the expert would be very clear. So the purpose, in sum, of the expert having such kind of expert is to allow swift introduction of expert knowledge into the proceedings and help the arbitral tribunal understand the technical matters. And this will probably help the arbitral tribunal to capture what actually is the real issue at stake, and if the need be, would may be suitable to ask the tribunal-appointed experts already provided under the UNCITRAL arbitral tribunal under the UNCITRAL arbitration rules to have a comprehensive report in writing. So, but this idea has some points to be clarified. Of course, it's not that the arbitral tribunal can have someone sit together who would whisper in the ear about what the right and wrong about the technical matters are. This is probably a big concern for the parties about transparency if the arbitral tribunals were to be involved in such a manner. So the other side being contemplated within this model clause is means or ways to ensure transparency. So we are still not yet there as to how this model clause may be finalized, but there are ideas to put in place language so that the experts do not whisper in the arbitral tribunal's ears, but rather to provide their explanations in front of the parties so that the parties can actually respond if the need arises. Other possible approaches are also being contemplated. There was an idea about having already an expert as part of the arbitral tribunal, but there were also counter arguments on this idea that having an expert on the arbitral tribunal might further make the process untransparent, as the expert in the arbitral tribunal might rely on its own expertise. So these are the ideas being contemplated with regards to experts accompanying the tribunal. So now finally, going on to model clause B plus guidance text. This is the model clause plus guidance text that addresses the issue of confidentiality. It is understood that there are two aspects to confidentiality. One is that information regarding the dispute that is not made publicly available should be kept within those involved in the case. The other is that certain measures should be taken when a party discloses to the other party information of intrinsic value to support its case, such as trade secrets and know-how to mitigate the risk of misuse of such information by the other party. And compared to court proceedings, arbitration does better in terms of confidentiality. Information regarding the dispute is basically not publicly accessible, but the rules, including the UNCITRAL arbitration rules, do not provide for confidentiality per se. So arbitration may do better by tightening confidentiality for tech or IP cases by making disclosure of information beyond those involved in the case unlawful. So what this model clause attempts to do is to achieve to put in place an airtight confidentiality so that information is not brought outside of the proceedings. So, but however, the tricky part is how to ensure that a party does not use information provided by the other party for purposes other than to defend itself in the dispute. This is probably an area where arbitration seems to have some weaknesses. For example, in certain jurisdictions, patent litigation provides for confidentiality protective orders for trade secrets, which are issued to prohibit the party receiving information from using information outside of the proceedings, and to not disclose information to those not subject to the order. Breach of the order constitutes a criminal activity usually in court proceedings and entails sanctions. In contrast, due to the nature of arbitration, it does not seem possible to ensure the same level of security. The working group is nonetheless contemplating the development of guidance to mitigate such risk of information being misused. So this brings me to the end of my first part of the presentation on tech-related dispute resolution. And but before I go to the next topic about dispute resolution and digital economy, just for your information, the working group has met, as I told you, in September this year, and it will be, and the Secretariat has been tasked to revise the clauses, and we will be presenting them in the not so distant future, and it will be further contemplated in February next year. And as I hear the chair's hope is to complete this work in the upcoming session in February next year to be presented to the Commission for adoption. So in the time remaining, I would like to be very quick to talk about the other dispute resolution project that is that the Secretariat is implementing for UNCITRAL, the stock taking of developments in dispute resolution in the digital economy. The project was launched back in 2021, so it's been here for quite a while. The Secretariat has been mandated to monitor the changing landscape of dispute resolution in the digital economy. But in a word, what we do is to explore the impact of digital technologies and technology-enabled services on dispute resolution is what we precisely do. And because at the very beginning, I referred to the fact that UNCITRAL being a legal body, developing legal text is what is at the core of UNCITRAL's mandate. So we do that with a view to laying the groundwork towards updating existing UNCITRAL texts or developing new ones. The focus of the project is twofold. One, on the disruptive or the negative side, there are concerns raised about technology having a negative adverse impact on the core principles of due process and fairness of dispute resolution, but also on the positive side, there's discussion about the enabling aspects of technology, impact on cost and duration, but the traditional norms that we have had for quite some time they still remain to be an obstacle to reach the benefits of technology to the fullest extent. So the DRDE stock-taking project is exploring questions such as what are the prevalent means of communication and arbitration, and which procedural steps remain paper-based? Are electronic awards issued in practice, and do legal frameworks need to be adjusted so that they are more conducive to the issuance and enforcement of electronic awards? What are the latest technological means used for the presentation of submissions and evidence in arbitration? And what is the state of play on the use of video conferencing in arbitration and in mediation? Where are we in terms of the use of AI? And what are the parameters of dispute resolution on online platforms and blockchain? Because this is UN work, ensuring comprehensiveness is key. So the Secretariat has embarked on an initiative called the World Tour. So we have implemented and planned discussions as listed in the slides. We had discussions in Tokyo, New York, Guatemala City, Paris, Vienna, Abidjan, and Singapore so far. And upcoming is another event in Hong Kong. And we have 2 other planned events and also in Cairo and Abuja, Nigeria next year. So due to the limitation of time, I will not go too much into the details of the project further, but as I mentioned in the previous slide, there is going to be an upcoming event to discuss the dispute resolution in the digital economy on the 8th of November. And here is for your information. And with this, and with my sincere thanks again, I would like to conclude my presentation, and back to you.
Okay, thank you, Takashima-san. And thank you all of my colleagues for attending today and for giving me the opportunity to discuss technology-related dispute resolution. Some of the things I will discuss, my colleague from Japan has already mentioned, which is an introduction to UNCITRAL, which is the United Nations Commission on International Trade Law. And its purpose is to harmonize private law across different jurisdictions. And it does this by giving advice and designing model clauses in new and developing areas. I remember when I was teaching contract law previously, and I would always give the example of if you send an offer to someone and they're on an aeroplane and they don't have internet on their phone and they can't receive it. There's some UNCITRAL rules about information systems. When I came to Qatar, all of my students would say, on Qatar Airways, we all have internet access. So the phone is all, we can always receive offers and accept offers. So the UNCITRAL rules weren't that helpful in that context. Okay, so the 4 areas that have been focused upon by UNCITRAL to look at developing dispute resolution is dispute resolution in the digital economy. And I would mention that here in Qatar, the new Qatar Trade and Investment Court, part of its jurisdiction includes resolving disputes related to electronic commerce. So it's not necessarily only arbitration in Qatar that would deal with technology-related issues, but there's also the Trade and Investment Court. Online platforms for dispute resolution. So we've seen Zoom and other online platforms like Teams, where you can have litigation taking place, you can have court proceedings, judicial proceedings taking place. Adjudication was also mentioned, but the one that we are focusing on today is technology-related dispute resolution. And in my presentation today, I'm going to talk a little bit about some of the preliminary things that maybe complement what Takashima-san was discussing, the model clauses. So I want to look at what is the rationale what is the reason for having a separate dispute resolution focused on technology only? Why are the courts inappropriate? And then also look a little bit further down the track and discuss or reflect on how technology is changing and how it's becoming a public issue more than just a private issue. So it was mentioned that the working group that the UNCITRAL had looked at this issue was Working Group 2, which was technology-related dispute resolution. But if you look at the way the technology is developing, it may well be investor-state technology disputes in the future, because technology companies are now being very, very influential, and they're being targeted in some areas like Europe. For example, Facebook is being targeted in Europe for monopoly power. So these are technology disputes that involve governments. Okay. UNCITRAL is not the only body that's doing work in this area. There's a UK charity association, which is called the Society for Computers and Law, which is headed by the famous Professor Richard Susskind, Professor on Technology and Law. And they are also designing rules relating to dispute resolution, relating to technology. So when we look at dispute resolution, generally, whether it's in arbitration or in the courts, we are balancing two competing interests. The first interest is party autonomy, which is the parties can choose how they want to resolve the disputes. Okay, and this might be motivated by efficiency or costs. But on the other side, we also need to consider fairness and due process, that any chosen method of resolving a dispute actually results in the dispute being resolved completely. The parties are satisfied that they have been given justice. So this is the context in which we examine technology-related disputes. We need to always remember first principles. These are the first principles of dispute resolution. Are technology disputes actually very technical, or is the dispute legal? I mean, a construction dispute might be technical, and you will have to go to arbitration and have expert arbitrators who understand construction. But whether you're selling high technology or whether you're selling cows to each other, there is a legal contract at the bottom of it, and there is a legal dispute. So one of the justifications for developing specific rules for technology-related disputes is that it's too technical to leave in the hands of normal judges. And that, I mean, specialization with judges is very common. You have family courts, you have courts to do with trade and commerce. So specialization in the courts is possible. But the other consideration is speed. The courts are considered too slow, and particularly in common law countries, they're considered too costly and very, very expensive. But there are ways in which you can make the process faster. There are specific applications you can make to the court for summary judgments or dismissal orders. So the courts can have the mechanisms to make disputes, to resolve disputes faster. So we shouldn't automatically assume that arbitration is the answer. One of the other justifications for this, developing these dispute resolution rules for companies is that you need to accommodate technology companies. And as my colleague Takashima-san mentioned, there are different kinds of technology companies. There are startups who don't have lots of money and they need to move quickly. And then there are big technology companies like Google and Facebook, and technology companies are not uniform. And so you may well need that flexibility of arbitration to accommodate the different requirements of different kinds of technology companies. So the fundamental question is, are the courts sufficient? And if not, are existing arbitration rules, UNCITRAL arbitration rules or other arbitration rules, are they sufficient? And do we need to refine these arbitration rules specifically for technology-related disputes? Now, one of the real difficult questions is, well, before I get to the difficult question, the UNCITRAL is given a mandate by the General Assembly of the United Nations to look at this issue. And I've been reading much of the documentation in the last few months, looking at the work. And what they've done is they, from my understanding, and I'm sure I'll be corrected if I'm not being accurate, is that they have developed 9 specific draft provisions to look at to help them to improve and develop the arbitration rules around the world. Okay, and that might apply to technology-related disputes. And these 9 provisions, you'll see them on the screen here, are the definition of what technology actually is. And if you look at some of the discussions they've been having at UNCITRAL, some of the comments are things like, a shovel is technology. Okay, is a dispute involving a shovel a technology dispute? How do you define technology? Where do you draw the line? Is it electronic? What are the characteristics? And then there are other provisions to do with things that are more familiar to arbitration, like time limits and choosing an arbitrator. And these things, I don't think they're very unique to technology disputes. Maybe time frames would be unique, as Takashima-san mentioned. 6 months for an arbitral award is too long. A lot of technology companies want 40 days or 60 days. And confidentiality as well. Technology is innovation. Innovation needs to be protected. Having trade secrets or patents. So confidentiality is particularly important in technology disputes and may not be as important in other disputes. So let me here just show you the draft provision relating to the definition of technology. And it says here, technology dispute means a dispute arising out of or relating to the supply, procurement, research, development, implementation, licensing, commercialization. So all aspects of commercial activity relating to technologies would conceivably be within the jurisdiction of a technology-related dispute. Now, I personally think it needs to be refined further and developed a little bit sharper, the definition. There are some examples given in the documents, and I'll share them with you now. It says here also, technology disputes may be varied in nature and arise out of ownership, licensing, financial issues, non-competition, confidentiality. So there's a broad scope of the type of technologies. There's a broad scope of the type of activities that might give rise to disputes. And there's a broad scope of disputes that can be settled. Within the discussion, it's made clear that any draft provisions or model clauses that are developed are intended to be used in a business-to-business context. So these are disputes between businesses. It's not a business-to-consumer context or a business-to-government context or consumer-to-consumer context. So those other relationships are better resolved in the courts through the judicial process. This is the perspective given. But as I will discuss in my next couple of slides, I think there also needs to be greater focus on technology-related disputes involving governments. Okay, because particularly when it comes to the data privacy of citizens, for example, GDPR and the data of European citizens is something that the European Union is serious about enforcing. So the examples given, I'm not going to read out this full paragraph of examples, but you can see that it includes everything from aerospace, biotechnology, legal technology, financial technology, nuclear physics, photonics, cryptocurrencies, blockchain, non-fungible tokens, cloud computing. All of these things are suggested in the documents as potentially being relevant areas where technology-related dispute resolution rules can apply. And everything has technology in it, you know, these days. Fridges have technology in them. You know, you wear things, clothing has technology, some clothing has technology in it. So the limit of the scope of this area is very, very broad. Increasingly, there are also technology disputes in the virtual world. Okay, just last week, my son, who plays Roblox a lot on the iPad, said that he lost all his money because someone scammed him. Okay, someone said do this and that, and he got scammed. And the question is, who's responsible for this? Is it the digital platform? Is it the other individual in the virtual world? And in the last few years, there has been a lot of talk about the metaverse, this virtual world that people will be going into and interacting in. You could imagine that there will be disputes in the virtual world just as there are disputes in the real world. So the scope of these rules may be not just business to business disputes in the real world. There may be other dimensions to the disputes. Okay. By its very nature, technology, one, it develops and innovates rapidly. Technology is changing rapidly. But it's also cross-border. You might have a service provider in America and you have the customer in Qatar, for example. Okay? So there are cross-border issues that may make it difficult for courts in specific countries to have jurisdiction over the matter. So having arbitration clauses and choosing a jurisdiction and then having rules specific to technology might be the only solution here because technology is becoming inherently international. Confidentiality is also a jurisdiction-specific issue. The confidentiality rules in Qatar might be different to the confidentiality rules in Japan. And so if you're having arbitration where confidentiality is an issue, the definition of what is confidential will also come down to specific jurisdictions, or the parties will have to choose which law applies to confidentiality. Okay. So geopolitics also involves technology at the moment. We've seen in recent years, for example, some countries like Canada have banned China from installing Huawei technology for 5G mobile phones. I think the US has also banned Huawei from, and these are national security issues. This has become a fragmented world. You have the Western countries that have their own technological sphere, like their own social media platforms, Facebook, and then you have, for example, China, who has Weibo and Alipay, and it has its own technological ecosystem. And so just like you have fragmentation in the politics, you also have fragmentation in the technology and in the standards. And this will become even more visible when countries start to introduce digital currencies and interoperable digital currencies. So you can use your Chinese digital currency in certain countries, Malaysia, Singapore, but not in other countries. Or you can use an Australian digital currency in New Zealand and America, but maybe not in China. So technology is becoming fragmented, just like the global geopolitical situation is becoming fragmented as well. And we saw, for example, technology like Starlink, the Elon Musk space internet service providing. It was used to give internet connection to people in Ukraine, and it was also suggested to be used in Gaza recently to give people internet connection. So that's a technology-related dispute, not necessarily business-related, but public international law rather than private international law. So this issue is developing and growing even further. Other perspectives are things like free speech and censorship. If technology platforms are going to take down people's posts or censor what they're saying online, this again is a technology-related dispute that is not business-related. The point is that technology-related disputes in an international context is, first of all, much bigger than private international law. But also, if you are going to try and develop rules for private international law to accommodate and support technology-related disputes, you really need to define technology clearly. What do you mean by technology? Because technology is everything from a pen to a quantum computer, okay? And with that, I will end my presentation. Thank you very much.
Thank you very much, colleague Mazen. You have brought our attention to the not only particularity of this domain, the technology-related disputes, but also the challenges that we are facing. And if we will take it from the perspective of the UNOCITRAL, they are trying their best to cope with the situation, to offer some solutions to these challenges, whether according to improving the rules or offering standard clauses to address the most important issues at stake, as I understand from the presentation of our colleague Takashi. Now, the floor is open to our colleagues to give us their comments or maybe raise questions. And before passing the mic to our colleagues, Dr. Mazen mentioned the Court of Trade in Qatar and its jurisdiction when it comes to e-commerce disputes. I wish to use this opportunity to praise the position of the legislator when it considered the e-commerce disputes among the disputes that will fall into the jurisdiction of the Court of Trade. You brought, Dr. Mazen, to our attention that we need to consider the special nature of the technology disputes when it comes to the court, specialization of the court. So we can say that Qatar is paying attention, at least partially, to this when it comes to the Court of Trade, especially if we will take into consideration that the definition of e-commerce in the Qatari law is not according to the narrow concept of the French law. It's not just acte de commerce. It's also acts, even if they are not specifically commercial within the doctrine, the French doctrine of acte de commerce. Then, though we have a court for trade, when we decided which types of disputes this court will hear, we adopted a modern and a wide concept, and I consider this a consideration for the speciality of trade, of technology-related disputes. Now we come to our colleagues who I'm expecting that many of them have now comments and maybe questions either to be addressed to our colleague Mazen or Mr. Kashi from the Institute. Who would ask first? We can start from the right, to my professor, to Matar.
Yeah, Dr. Nader, I really enjoyed both presentations very much. Very informative in perhaps a new development in the law itself. And I am familiar with the unilateral or unilateral, so Dr. Salim doesn't get back to me with correction of the spelling. The new draft model clauses that target technology disputes. My question is very simple. If I am drafting a clause and I am in this zone, technology dispute, how does a clause read when the dispute is related to technology? I understand the considerations, I understand the confidentiality issue, I understand all that. But in terms of drafting, I would love if you share with us a model clause and say, here's how you draft an arbitration clause when you are drafting in the area of a dispute that is related to technology. How is the drafting different if you are drafting a clause in the area of a dispute that is technology related? Is it different, or you talk about how does it affect the drafting of the clause itself? How does it read? And I have two models of the unilateral that have been developed. Can you share with us one model and tell us here's how you draft?
I don't have any models on hand, but Takeshima-san, did you hear the question? Would you like to comment on anything?
I'm terribly sorry, but I was unable to capture the question.
Okay.
I was trying to listen.
Okay, I believe the question was on drafting clauses that make a dispute or define a dispute as being technology related. How would you draft a clause that clarifies whether a dispute is technology related?
Yeah, I think, well, I think the answer to the question was already in Andrew, your presentation, I believe, about the definition and scope and the challenges of defining technology-related disputes. As Andrew, in your presentation,
Yeah, I would say that the parties, the clearest way to do this is for the parties to consent that the clause is clarifying that both parties consent to characterizing their dispute as technology related, and thereby engaging those relevant rules, because it would be too difficult to capture all of the variations of what technology can be. So the simplest approach is usually the best, and I think the simplest approach would be that in a contract the parties would agree that this contract is related to technology issues, technological issues, making it a technology dispute.
yeah, I think you led us directly to the conclusion. Yeah, party consent is probably the way forward. Yeah.
Thank you both. That was fantastic and very illuminating. I was just wondering if you could speak for a moment on talking point number 5, enforcement of ADR
For the records,
awards.
would you please present yourself? Introduce yourself.
Forgive me.
Takashima-san, hajime mimashite, dozo yoroshiku onegaishimasu. My name is Professor Charles Schnerman. I'm actually a clinical lecturer of law here in the Legal Skills Department at Qatar University. And my question is in regard to talking point number 5, the enforcement of ADR awards in international tech cases. Does the fact that it's related to tech mean that we're reinventing the rules of enforcement? Is this something that's being contemplated?
Is this for me or Takashima-san?
Well, for both. Well, let's start with you.
No, I think enforcement's always challenging, okay? And then enforcement may require you to engage the judicial process in a particular jurisdiction to realize the award. The fact that it's technological may present a problem if the jurisdiction in which the award is to be enforced is not what you would call a friendly jurisdiction. Probably the only challenge would be the scope of relationships that technology can foster, and so the potential disputes are much broader than traditional bilateral disputes.
I may, can I?
Yes, sure, of
Of
course.
Actually, what would be the effect on the resolution of a technology-related trade dispute in a large extent depends on the applicable law, on the contract. I have an example for that. Under the Egyptian trade law, it was made in 1999, we have an express provision regarding arbitration when it comes to transfer of technology contracts. We allow the parties to agree to go to arbitration, but we restrict that, and we will require that the place of arbitration to be in Egypt. So, largely speaking, I may conclude by saying we have to take into consideration conflict of laws and possible applicable rules on the substance of the contract of the transfer of technology. This is my comment, if I may. Yes, Doctor. Our colleague, Dr. Mohammed Al-Faraj, تفضل.
Thank you. Mohammed Salim Mufarag, okay, Professor of Commercial Law.
Definitely, it might provide great
just
benefit
drafting
in terms of
special rules for dispute resolution relating to new technologies or, okay. It's about getting specialized judges, arbitrators, mediators in the field in order to overcome the issues related to the new technologies, okay? So you might have, like what Dr. Mohsen a couple of times, we discussed this a couple of times about the newly established court here in Qatar, okay? The investment and trade law. It's a wonderful court. It's about the speed. Yeah, within a couple of months, the case is already resolved. But are they specialized in such technologies if there is any dispute related to it? So it's about, again, getting, no, I'm being frank. We have to be frank.
Yes, I will pass the question to be answered by one of our colleagues of procedural law. Maybe one of them have comments about specialized courts and whether the trade court is a specialized court. I respect specialization. Okay, I dragged you to the floor. Now the comments from our colleague, Dr. Ahmed.
Professor Ahmed Mahmoud, Professor of Civil Procedure Law. Okay, that's okay. Professor Ahmed Mahmoud, Professor of Civil Procedure Law and ADR. First of all, we have to distinguish between the technology as the object of the disputes and the technology, on the other hand, at the moyen or at the mean of the disputes. When we talk about the technology-related disputes with litigation or court, judicial court, we have here in Qatar a specialized one. It's called Court of Trade and Investment. It has like 20 disputes in its jurisdiction. One of them related to the in express provision, technology disputes. I agree with my colleague, Professor Mohammed, that we don't have a specialized judge here in Qatar. And I think the Ministry of Justice here, they have a list of a specialized expert in technology disputes. But the speciality here should be in broad scope, not only for the expert, it should be for also the judges. And we don't have here also a huge number of technology disputes in Qatar. The most important thing in my view related to this kind of disputes is that the users of this technology are not always unknown persons. They could be unknown persons. And few days ago, I did a research in the judicial service by NFTs, one of the technology of blockchain. I found that there are 2 judgments now in the wallet, or like 3. One of them from Canada, the other from US, and the last one from, I think, Indonesian court. They managed the case, although one of the parties of this case was unknown. How they send the judicial service, the judicial notification, they served this unknown person by his e-wallet, and they use a third party joining. And this is the answer for Professor Mohammed Matar. What is the peculiarities in drafting the arbitration clause regarding this kind of disputes? One of them that we will face, one of these parties will be unknown, anonymous. So these courts found that the best kind of service will be to send the writ of the action by his e-wallet. And they used that there are many now exchange regarding the cryptocurrencies like Bitcoin and this new technology, especially also for the smart contract. Is the Arab legislations already for face or challenge or face these challenges regarding this new technology, metaverse, cryptocurrencies, fraud? Are they ready? I think they are not ready yet. We have to issues more legislations, especially with this kind of disputes, and especially with the field of procedural one. And the last thing I would like to say, this is the first step here in Qatar to face this kind of technology disputes, that they had established this new court. Although they don't have a specialized judges, but I think it's the first step. And as my colleague Professor Mohammed said, that the clearance of the disputes there in this specialist court is within 6 months. 6 months, and without specialized judges, we cannot success in these long proceedings. I think it's a good step. After a while, we need more number of judges to be specialized in this kind of dispute, technology disputes. Thank you very much.
Further comments from our colleagues, and until we hear one, from my side, I may say that the Court of Trade now in Qatar is speedier than arbitration in Qatar.
I agree with you.
I'm appointed in many cases, and I'm telling them now we are less speedier than the Court of Trade, and this should be addressed when it comes to arbitration. But at the end of the day, the arbitration is in the hands of the parties. If they are not cooperating with me as an arbitrator and deciding for time limits for exchanging of submissions, 2 weeks or 3 weeks, and at the beginning, I was objecting 1 week. I wanted to make a score. I was a sole arbitrator in a case. I wanted to score the shortest, speedy arbitration. But what can I do if the arbitration, the counsels of the parties are not cooperating with me? It will take more time. And coming back to the question of my colleague, Dr. Mohammed Abul Farag, and it is a very important question regarding the specialization of the judge or arbitrators. Here, when it comes to arbitrators, we will not impose the arbitrators on the parties. They will choose their own arbitrators. And we expect that they will take into consideration their experience, whether they are experienced with technology or not. And what if they haven't paid attention to that? Again, it's in the hands of the parties and their counsels, and we cannot impose on them, oh, no, you made the wrong choice. It's up to them to make their choice. And actually, the idea of specialized courts and specialized judge was always there with all types of disputes. But let's be realistic. All topics have their own particularities. If our argument will be for each dispute we have a specialized judge, at the end of the day, we will need to have judges in different courts for each category of disputes. So this is why, at the end, we say, why can't we do, as the ancestral paying attention now, to the idea of a technical assistant that will help the court? They are discussing it in arbitration, but I think in courts, why can't we one day, Dr. Ahmed, you are a professor of law procedure, can a court ask for an expert to tell her how to deal with the questioning of another expert to help the court to phrase its mission? You are nodding by saying yes.
There are two kinds of experts.
Back to you.
Yes, there are two kinds of experts mentioned in the law of trade court. The first one is called the consultant expert. It's appointed from the party. And the other one is the judicial expert appointed from the court. So the court had the authority to appoint an expert one with this technology disputes. And the court can give him like some of questions to answer. But at the end, the report of the expertise will not be like obligatory for the court. The court can go on the other side because, as we know, the court is the higher expert. Thank you.
We have a couple of minutes for our colleagues for further comments or questions. Yes, please, go ahead. Dr. Az, he's fond of the AI, and maybe he brings to us something related to it. Go ahead, Dr. Az.
Well, as you know, there is like a growing interest in utilizing artificial intelligence in judicial decision making, and various countries in the regions issued policy documents stating that this is one of the objectives in building the technical infrastructure for artificial intelligence technologies. And possibly since 2017, there are several examples of using artificial intelligence in augmenting judicial decision making. Definitely it might provide great benefit in terms of commercial disputes. That might happen in two ways. First, in terms of speed, and the other one in terms of contextualizing technicalities to non-specialized judges. So my question is there any efforts on UNICITRAL level in building that kind of technical infrastructure? Because I hear that now there is like working groups focusing on technology as a means to resolve disputes. Is this one of the objectives, giving the hype and the momentum at the moment with large language models?
Thank you. I think I captured the question. AI is a very hot topic, also in UNCITRAL, in the field of dispute resolution. We are closely monitoring the development as part of the project of the dispute resolution in the digital economy. But the preliminary findings show that it would be a little bit premature to draw any conclusion as to what kind of guidelines or regulations we can put in place for dispute resolution in this regard. The technology is rapidly evolving. We've heard about US court judges placing standing orders prohibiting or asking counsels to certify that they have not used artificial intelligence or have reviewed the drafting of their submissions carefully. So this is probably one detail or concrete example of what kind of regulations might be necessary in the future. But I think it's again still a bit premature to understand the full picture of where the rules developed by the need for the rules might be in the future. So, but again, it's a very important topic that we will continue to monitor very closely. So,
I just want to say a few words on that as well. Actually, draft provision 8 of the UNCITRAL rules on evidence mentions artificial intelligence specifically, and it says, if artificial intelligence is used by the parties to prepare and analyze their case with no direct impact as to the documents or information presented to the tribunals, it's legitimate. If, however, the AI is used to collate documents or information submitted or disclosed during proceedings, some regulations may be necessary. Okay, so using it internally at the moment is fine. There's no, if you're using AI to scan lots of documents to prepare your case, no issue. But once those documents leave your side and enter the tribunal, then UNCITRAL has said we may need to look at this to regulate it.
You mean like the use of AI in augmenting the decision making? So it's one thing to say that to use AI to generate text, for example, submission. Other thing to assess the evidence and their validity. Is this what the
I think what they're talking about here is just organizing like large volumes of documents, using AI to scan documents and categorize them and things like that. It's legitimate, but it's not talking about large language models.
Perfect. I might borrow that from you, and if you have it. Thanks, man.
We coming now to the last step in our round table, but before we go into it, I would like to thank the UNCITRAL and our colleague Takashi Takeshima for his efforts and for his time. Of course, we extend our best regards to all the members of the team. I told you, Luca Conestanale in person, and we wish the UNCITRAL the best with the rest of the agenda. It's a very impassioned agenda, and we are looking forward for further cooperation with the UNCITRAL. We are very proud at our college in the university of our cooperation with the UNCITRAL. We consider it as a strategic partner, and we will be very proud of today's event, and we will look forward for further events. And with this, we come to the last words of conclusion, which would be presented by my colleague, Ms. Reem Al-Khal.
Ladies and gentlemen, distinguished guests, speakers, and participants, I would like to express my gratitude to all of you for your participation in this informative event, the Qatar UNCentral's Day Roundtable on Trends in Resolving Technology-Related Trade Disputes. During the past 75 minutes, we have had a productive session, and I would like to summarize our key takeaways. To commence, we received an introduction to the event's significance and were introduced to our two main speakers, Mr. Takashi Takashiba, the UNCentral's legal officer who shed light on UNCentral's global contributions in resolving online disputes. Emphasizing their crucial role in this domain, we are appreciative of the insights shared by Mr. Takashima, which have enriched our understanding. Our second speaker, Dr. Andrew, our colleague from the College of Law, who explored the complexities surrounding online contracting. These complexities pose challenges and potential risks for online cross-border transactions, which Dr. Andrew illuminated during his presentation. Throughout our discussion, we explored several key topics, including the choice between arbitration and litigation in online transactions, ensuring fairness in online dispute resolution processes, the enforcement of ADR decisions in online transactions and litigation, and safeguarding associated rights. Your questions and insights have further enriched these discussions, making them even more insightful and valuable. I wish to extend my sincere thanks to our speakers and all of you for your active participation, which has made this event engaging and informative. Your contributions have been instrumental in shaping our understanding of the online dispute resolution and transactions. Looking ahead, our journey continues. We have a range of activities, workshops, webinars, and discussions planned to delve deeper into the subject. We eagerly anticipate our upcoming events, particularly those in collaboration with UNCentral, where we can continue our conversation and learning. Thank you once more, and we look forward to seeing you all in the near future. As we reach the conclusion of this remarkable roundtable, I officially declare the event closed. Thank you.
Thank you.